Hi, this is Kina Kim with PivotalDiscovery.com. We're here at the Thomson Reuters 12th Annual E-Discovery and Records Retention Conference here in San Francisco with Laura Kibbe, who's going to share her thoughts and perspective on e-discovery from an in-house counsel's perspective.
Well, thank you. I guess the first thing I'd like to say is the globalization of the company. Anytime you have a corporation as a client today, it is more likely than not key information for your U.S. discovery operations is going to be outside the U.S. shores. And that could be either because the company's broken up into subsidiaries that for various reasons live outside the United States, or from an outsourcing perspective because of the economic constraints that companies are moving pivotal operations offshore to save money. Regardless, if you are the in-house counsel and the information is required for discovery, you're going to have to figure out a way to get that information back to the U.S. for discovery. And in some countries, for example, the UK, it can be very easy. Simple consent forms, simple kind of heads-up email notifications that the information has to be moved, and you're done. In other countries, particularly the Frances, Germany, Switzerlands of the world, where they take the EU Privacy Directive very seriously, there are a lot of hoops that have to be gone through before you can safely move that information back. What most people forget is all of this takes time. You don't go and get all these consents and get all of this done in a day and a half. So you have to build that. That should be an initial question that's asked at the start of the case. Is any of my information somewhere other than the United States? And then get a realistic perspective about how long it's going to take to get it back, if you can get it back at all. One of my experiences was, given the hoops that I had to jump through in a German court, I wound up bringing back the equivalent of 9 files. At the end of the day, all of the time, all of the effort, everything that was put into it between my time, my outside counsel time, to come back with 9 files, probably it wasn't worth the effort at the end of the day. But if you don't acknowledge this kind of issue up front and really know where the data is and make a contingency plan, or candidly just have an open discussion with your adversary explaining the difficulties of getting certain types of information back, then you're going to be unprepared and likely start blowing deadlines. One of the other issues to be very cautious of is if you are in-house counsel and you hear that the company is doing things, outsourcing to particular countries, moving things. The joke is, if somebody comes and says, can I move all of my email servers to France? While it does appear funny, it is the in-house counsel's responsibility to make sure that the company doesn't go and make information otherwise accessible and producible in the States inaccessible because they've chosen to move it to a country where the privacy laws would prevent its export back to the United States. And only an in-house counsel is in the position really to know when those kinds of discussions are taking place inside the IT department.
Right, great. Thanks very much, Laura.